Hello again. My name is Jonah. I'm the director of the Land Use Education Program, which is, of course, a partnership between Virginia Cooperative Extension and Virginia Tech Center for Public Administration and Policy. I'm being joined today by Andrew McRoberts, who himself is one of our team members, I like to think of him, that teaches with the LUEP program. Of course, he has a day job, and he is the head of the government group at Sands Anderson, where he brings many, many years of experience from dealing with things from a county attorney's perspective. He's also, and aside from being a county attorney, has been involved with the local government attorneys association. He was the president not too many years ago. And so we're always happy to have him involved with our programming when time allows. And of course, he's part of our Certified Planning Commissioner program and BZA program as well. We're going to be talking about BZA Law today, and we had a big change in the law, or maybe we didn't, in 2015, and Andrew's going to fill us in as to whether or not it was a big deal. Of course, that is part of how things go in Virginia and in many states. We have changes in the law, and we have to understand the implications of those laws. This is one of many Webinar Wednesdays that we've had. So far, we've talked about sign ordinances and vested rights, among other things. If you have a topic of interest that you'd like to have us investigate, we'd be happy to find some presenters, or maybe you'd like to be a presenter. Just give me a call or email me. I'd be happy to talk to you about that. A few housekeeping items before we get going. Again, for today, you'll see hopefully a link that will appear in the chat box just to the right of the video that will contain a link to the evaluation for today's webinar. Hopefully we'll get some comments about the link being broken and fixed. That's always an issue. We understand that, and so hopefully things have been rectified at this point and everybody's having a good experience. The other thing you can do in that chat box is ask questions. So as Andrew goes along in his presentation, feel free to log into Google, first of all, and then use that chat box and ask Andrew a question. If I see something come up that's worth interrupting him, I'll certainly do that. Otherwise, we'll hold our questions to the end, and you can type those in at any point. This webinar, of course, is brought to you by Sands Anderson and LUEP, and also APA Virginia chapter. We're partnering with them to offer AICP credits. We're going to get you 1 credit for this webinar and 1 credit for every other webinar that you attend. And hopefully, if I'm lucky, I'll start working with VAZO. And for anybody who is looking for CEU credits with VAZO, I'm going to hopefully have some good news for you in not too distant future. With that, I'm going to turn things over to Andrew McRoberts, who's going to make a presentation for us today again about BZA Law. Andrew, thanks for sticking around. Appreciate all the time you spend with me. It's always a pleasure.
Sure. We ready to start?
Absolutely. If you could just very quickly give us sort of a very like 2-sentence introduction on how does Board of Zoning Appeals law fit into the larger community planning perspective. I think that'd be helpful to just kind of orient folks on where we're at with the current updates. And feel free to use that screen share button and share your PowerPoint as you need to.
Okay, let me pull that up. Okay, can you see me now? See this presentation?
I see you.
You see you. Well, that's not going to be good.
Nobody wants that.
No. Let me see if we can't get some technical assistance here. Okay, I did that.
Yep, and just pull up your PowerPoint.
Okay, there we go.
There you go.
Okay, thanks. Appreciate you.
It looks like we do have some viewers this time, so we're not talking to ourselves in the
okay, good. Well, welcome everybody. Appreciate you being patient and waiting on us. So we had Google issues this morning, and as my son told me one time, one year very soon, Google's going to start running everything, but we're going to be okay with that, he says. So I don't know. Maybe this is an indicator that perhaps we wouldn't be quite as happy if Google ran everything as we thought. We're talking about variance law primarily, but also what's happening at the BZA. The General Assembly adopted a new amendment to the statutes involving the BZA last year. And so we're going to be discussing about what changed and maybe what didn't change, both for the variance standard primarily, but also some of the procedural changes and things that affect our staff, our zoning staff. I think that's also a very critical part of this that has been needed to be interpreted. There's my contact information. If you need to get a hold of me, you can certainly send me an email at amicroberts@sansanderson.com. You can find me on the Sans Anderson website. The local government blog is there, valocalitylaw.com, or you can find that on the Sans Anderson website also. As Jonah said, I've been doing this a good long time and have made a sort of study of different things, including vested rights from last week and BZA law from this, which we're talking about this week. This is the information on that bill from last year. If you're looking for it, that's the House bill number. You can find it in the Acts of Assembly at Chapter 597. Took effect July 1st. And so the keys we're going to be talking about today is, what did this bill do to the variance standard? And like I said, what did it not do, perhaps? And how much did this new statute that they adopted, this new section 15.2-2308.1, change the procedure and staffing to the BZA? A little bit of background first. Traditionally, given the fact that a zoning ordinance is a general regulation and land is unique, a variance was intended to be a relief valve so that a property owner who had unique physical conditions on their property is not left without, some reasonable beneficial use of their property and thus suffers an undue hardship. A little bit of further background. Zoning really began, well, land use regulation has been around as long as there's been government and land use, really, and certainly in the modern area, that's true. But zoning proper started in the progressive era in the early 20th century as a way to sort of react to increasing industrialization and urbanization of our cities and a need to really protect the health, safety, and welfare of the citizens. During that period of time, the idea of adopting general land use ordinances that would say these uses are okay in one part of the locality and not in the other, and let's separate the uses and have more governmental control over where those uses are so that those uses are not adversely impacted by one another. But it was envisioned even back then in the earliest days of zoning that zoning was a general regulation. And land is unique. And so there are situations then, as now, that the zoning regulation just didn't fit on a particular piece of property because the unique size, shape, topography of that particular parcel. And so as to not leave folks with a uneconomic remnant, basically, they said, let's have variances that are granted by this Board of Zoning Appeals that sits sort of quasi-judicially, hears the facts of an application, applies it to the variance standard, and can grant that pressure relief, that variance, so that then they can actually get economic use out of their property. It was never intended to be a way to bypass the general law. It was always intended to be a way that a property owner who's unfairly and severely impacted by a general regulation based upon their particular parcel to get relief from that. And Cochran case is a good example of that type of case. Cochran case was decided in 2004. It was actually 3 different cases that were combined from 3 different localities and made their way to the Supreme Court. They were combined for decision. And each one of those cases, the landowners presented, fairly compelling reasons why they wanted to get a variance. They had topographic issues, they had size issues, they had sort of family hardship issues. They had various other things that they said, well, these are the reasons. In 2 out of the 3 cases, they actually got the variance granted to them by the BZA, and on appeal to the Supreme Court, ultimately, the Supreme Court overturned all of them and said that a variance was not appropriate in any of the cases. And really the linchpin of each one of those was that the BZA was unable to find the necessary things in the statutory standard that would qualify for a hardship. Now they talked most significantly in the Cochran case about the the sort of various parts of the statute that would lead one to grant a variance, and in each of those cases found that they had not met the standard. One, they wanted to put a garage on; another one, they wanted to put a side addition on; another one, they wanted to put a storage building on. And the facts in each case showed that they could have achieved basically their goal another way, either by attaching it to the house in the case of the garage or storage building, in building it on the other side of the building in the case of the addition on the side, various other things that certainly weren't what the property owner wanted, and in fact, to the property owner seemed to be a hardship. Maybe it was more expensive. Maybe you just simply didn't meet their needs. But the Supreme Court in each case said that's not an undue hardship. That's not a unreasonable restriction on their property, and so therefore you don't get it. Now, after that, the General Assembly did act. They amended the statute, and they struck the words approaching confiscation, because up until that point, the standard had been undue hardship approaching confiscation. But there was no other amendment to the statute. All the other requirements that a BZA must find in order to grant a variance were unchanged. So the debate raged among local government attorneys and zoning administrators as to what did change, if anything. Certainly the General Assembly meant to do something, but what did they change? The Supreme Court finally answered that question, at least in my opinion, and some others, in 2013 in the Martin versus City of Alexandria case. And really they didn't change much, if any. And the reason is that Martin did not meet any of those things in the variance standard that they need to show. Despite the striking of the approaching confiscation requirement, they still had to show everything else. They needed to show that the strict application of the unreasonably restrict the use of the property was there. They had to show undue hardship, which at that time was still in the requirement. They had to show that the hardship was not shared generally amongst folks. And they also had to show that the condition was not so general or recurring as to be able to be addressed by a general zoning amendment. I will say that 3 out of the 4 are still in the law. And so if that telegraphs where I'm headed with this, maybe it does. Now, in response to Martin, the General Assembly did adopt that 2015 legislation that we talked about early. And the question is, did it substantially change the standard for a variance as applied by the Supreme Court in Cochran and Martin? So let's talk about what this new variance standard says. Now, most significantly, the variance standard strikes the undue hardship requirement. You won't find the words undue and hardship linked together in the statute at all now. And it does move the unreasonable restriction on the utilization of the property from one location in the statute to another. And it also moves it from 2309, 15.2, 2309, up to the definitions section, and actually makes this unreasonable restriction on the utilization of the property part of the definition of a variance. So that is a very interesting way to handle it. They did not change the other things that I know local governments are concerned about sometimes. Some people apply for variances as to use or density and other things like that. They are still not permitted. That's not changed. Let's look at the definition of variance. The definition of variance as amended by the General Assembly is on your screen. And as you can see, it struck the unnecessary unreasonable hardship to the property owner and replaced it with the unreasonably restrict the utilization of the property. Like I said, that's language borrowed from elsewhere in these statutes. It also added shape and height to the things for which you can grant a variance. And it struck the term substantial justice being done. And so, but the question is, what did all this do? Let's start with the easy one. Substantial justice, I've always viewed this, and I think most folks have seen it this way. It's a problematic term. Like I said earlier, the BZA is sitting quasi-judicially to apply facts to law, and expecting the BZA to apply some kind of amorphous standard like substantial justice. It's almost inviting the BZA to sort of say, well, what's fair, which is not the standard, and the Supreme Court has said that time and time again in cases like Cochran and Martin. So given this, I don't think that striking that is really any loss to anyone. applicants or land or localities, and I don't think it changes the law. It did add shape and height, which does add these two types of bulk regulations as things that can be varied. I think that probably will help everybody get to the proper result in proper variance cases. Let's talk about the difficult one now. It did strike result in unnecessary or unreasonable hardship to the property owner, which is, really the touchstone of variance law. I mean, that's really the major language that's been applied in most cases, really as long as there have been variances. Now, instead of that, unreasonably restrict the utilization of the property is now in the definition. And so anytime a BZA is asked to give me a variance, they have to find not only all the other things that they have to find in the statute, but they also have to say that it meets that definition. And so one can argue that they've, in the General Assembly, at least in this small way, has perhaps made it more difficult. Because now in every single case, the BZA must find that unreasonably restrict the utilization of the property has to be true, or else it's simply not a proper variance. I think it's significant that if you look at the Martin case, unreasonably restrict the use of the property was one of the 4 alleged bases for the variance that was found not to be met in Martin. And like I said, the term was already in the statute, although it hadn't been applied nearly as often as the other, undue hardship. There were significant changes to this variance standard, also not just in the definition of variance, but also in the actual standard itself, which is found under the powers and duties of the BZA in 15.2-2309. And it basically says now a variance shall be granted if the evidence shows that the strict application of the terms of the ordinance would, and here's the term, unreasonably restrict the utilization of the property, or that the granting of the variance would alleviate a hardship due to the physical condition relating to the property or improvements thereon at the time of the effective date. Is this a loosened standard? Certainly hardship no longer has undue in front of it. It talks about relating to the property or the improvements thereon, and that's arguably a loosening. But as I said, the variance definition itself does have the first of those two embedded in it. Now, I put those numbers in there. That's not actually in the code, but I put it in there to show that when you get to 2309 and the variance standard, there's an either or, that the BZA has to find one or the other of these things, and as you see at the bottom, and 5 other things that we'll talk about in a minute. But sticking strictly to this first either or, it is very interesting that the General Assembly chose to say it's 1 or 2, but then in the very definition, sort of the bedrock of what a variance is, they put number 1 in. And so I think there's a very good argument that number 1 has to be shown in all cases. We shall see as these cases get decided. Like I said, not only do you have to find one or the other one of those things, and perhaps both in some cases, but there are 5 other findings that are mandated. Most of these are largely drawn from existing law. They have been tweaked a little bit. I don't think they've been tweaked in any way that really significantly changes the ability to get a variance. But here are the 5 findings that are mandated. And it is significant that unlike the last slide that showed the either or, one or the other, this one says and, which means the BZA has to find one of those other 2, plus has to find all 5 of these. It's 1 and 2 and 3 and 4 and 5. So these are findings that are mandated. The lack of any one of these findings means there is no variance that's appropriate. The first one is the property interest for which the variance is being requested was acquired in good faith, and any hardship was not created by the applicant for the variance. There is case law on this going back decades on what is a self-imposed hardship. A self-imposed hardship has always barred a variance. There's case law talking about a landowner that hired a surveyor, and the surveyor got the property boundary wrong, and so therefore built it in the wrong place. Is that a hardship? No, it was created by the landowner's agent. Therefore, no variance is appropriate. So this is essentially a reiteration of existing law. This does not make it any easier to get a variance. The second one is the granting of the variance will not be of substantial detriment to adjacent property and nearby properties in the proximity. This wasn't actually in the statute word for word, but there was language in the statute before talking about effect on the neighborhood and whatnot. So I don't believe this is a substantial change. I think this is a reiteration of existing law, and certainly in my experience, it's a reiteration of how BZAs truly applied the variance standard. I've not very often seen a variance granted when there's a horde of neighbors in the public hearing complaining about the granting of the variance. On the other hand, I've often seen variances granted improperly when there's no one in the gallery to complain. The next two, 3 and 4. Number 3 is, and again, these are things that must be found by the BZA or there is no variance. The third one, I think, is perhaps one of the most significant ones here, and it is no change from the current law. It says the condition or situation of the property concerned is not of so general or recurring a nature as to make reasonably practicable the formulation of a general regulation to be adopted as an amendment to the zoning ordinance. So essentially what this says is you can't get a variance if the local governing body could address the issue involved here by a general regulation. This goes back again to the purpose of a variance itself. It can't be a general problem. It can't be a shortcoming in the ordinance. It has to be something that a general regulation simply can't address because of the unique characteristics of that particular piece of property. And so if a general ordinance amendment could be envisioned to address the problem, you don't get a variance. Now, there's a lot of zoning ordinances out there, and there's a lot of creative zoning administrators. There's a lot of creative local government attorneys, and there's a lot of creative governing bodies that know how to address problems in zoning ordinances. Fairfax zoning ordinance alone is about 8 to 10 inches thick. Last time I looked at it, it might be thicker now. I suspect that there's a lot of general regulations in there that could probably be used to fix most any problem. And I will say that, you know, if you just simply apply this language, for example, to Martin, this is one of the things that the Virginia Supreme Court found was not met in Martin. This is one of the things that would not have helped any of the 3 fact patterns in Cochran. Could, in Cochran, the general, the governing body have adopted a different setback or a different regulation on square footage for unattached garages? Absolutely. Those things could have easily been addressed, but the general, governing body did not. But they could have been fixed by general regulation. I think this being a mandatory finding is a very, very big bar to the granting of most variances. The fourth thing that must be found by the BZA is that the granting of the variance does not result in a use that is not otherwise permitted on the property or a change in the zoning classification. Again, this is a complete bar to use variances. You can't just come in and say, well, I would like to have a variance in the use regulations to allow my use. That's just simply prohibited. Variances are bulk regulations due to the shape, size, condition of that particular piece of property. And you cannot get a use variance. I know that was something that was of concern to local governments across Virginia and was discussed and specifically put in to this statutory amendment at the request of local governments. The fifth thing that must be found by the BZA in order to grant a variance is that the relief or remedy sought by the variance application is not available through some other process. This was also put in at the request of local governments, which feared that, wait a minute, we've already got special exceptions. We've got the ability for administrative modifications by the zoning administrator. We've got the ability to grant special exceptions either by the BZA or by the governing body. And so, this, that you can't, a variance is not that. If you could get a modification or a special exception through one of these other provisions, you must go use them. You may not use a variance as sort of an alternative. One thing I would like to say before we go on any further, that this change in the variance standard applies even in cities and towns with charters. There's language at the very beginning of this in the statute that says, notwithstanding any other law, and including special legislation or charters and things like that, this is the standard. So even if you have a charter that has a different standard, this standard that I've just gone through is now the law of the land. So has it really changed? As I said, major bars to variances still exist. Unreasonable restriction on utilization. What does it mean? Like I said, in Martin, that was one of the things that the Martin Supreme Court said was not found. It was alleged, it wasn't found. But what is it? Is it a legislative standard? How the BZA is sitting as a quasi-judicial body, and you would say, well, they're not a legislative body. But I think it's important to understand, what does the language refer to? The unreasonable restriction on utilization is talking about the underlying zoning ordinance itself. And when courts have reviewed underlying zoning ordinances for what is an unreasonable restriction, they have always applied the legislative standard of the fairly debatable rule. The fairly debatable rule simply says that if there is some evidence supporting the reasonableness of that particular legislative act, and there is some evidence that says that it's not reasonable, that it will be upheld in every single case. There is a burden shifting mechanism the Supreme Court has relied upon for years in cases of legislative acts, applied most famously perhaps in the Snell case. Essentially, if the applicant shows evidence of unreasonableness, the burden shifts to the local government to show some, in fact, any evidence of reasonableness. And if the local government can bear that burden, then the legislative act is upheld. Is that the standard? I think that there's good arguments either way. Certainly, I think local governments may very well be in a good position to argue that unreasonable restriction is in fact a legislative standard, because it's talking about unreasonable restriction by the underlying ordinance. And when zoning ordinances are reviewed by the courts to be unreasonable or not, they use the fairly debatable standard. But even if that standard is not used, and I will say in Martin they did not discuss this standard at all, it's still a fairly high bar, because what is unreasonable? Could, for example, you attach the garage instead of making it a freestanding garage? Could you reduce the living space that you propose by 125 square feet? Things like that. Could you move the building 2 more feet to one side? Are those types of things unreasonable restrictions? I would argue they are generally not. And so I think a lot of this is going to come down to findings by the BZA. And I think that local government attorneys and zoning administrators should work with their BZAs to try to make factual findings on these points, so that then when they're reviewed by the circuit court, there is a record and factual findings that are reviewed. And then certainly when these matters are reviewed on appeal to circuit court, that there is a record for a potential review by the Supreme Court. The second major bar is the one that I talked about significantly earlier. There has to be the ability to have no general resolution of the problem being addressed by the application for variance. Whether it is, as in Martin, the problem of I'm in a historic district, or the problem of, I need more square footage. Those types of things are really general resolution issues. Could the city of Alexandria amend their historic district ordinances to be more flexible? Absolutely. Could they amend it in other ways? Probably. That being the case, I find it very difficult to see that these types of things would get variances in a normal case. Now, that doesn't mean that if there's not some particular unique, narrow, topographic, other issue about how this property actually sits, that the standard couldn't be met. But I do think, as I said earlier, that local governments are very creative when it comes to finding general resolutions to problems that could lead to an application for variance. And then, of course, the hardship has to be due to a physical condition. That's something that restricts more applications for variances than you would think, because that's pretty obvious under the old law and the new, that it has to be a physical condition on the property itself that's unique. But time and time again, you see amendments that say applications for variances that ask for use variances and variances that have to do with what the property owner's intended use is, or things that that they would really like to do, but not necessarily having anything to do with the physical condition of the property. At the bottom of this slide, I say, would it have changed the result in Cochran? I think that's a fair question. I think that if you took this standard and you go back and go through the facts of Martin and you go through the facts of Cochran, I think it's a fair argument that this new BZA amendment in 2015 would not have changed the result in any of these cases. Now, I think reasonable minds could perhaps differ on that. I suspect that the folks that were behind the bill to amend the variance standard might very well differ with this opinion. But I think the facts and the holdings in both Martin and Cochran are self-evident that when you meet all the requirements in the statute, you get a variance, and when you don't, you don't. And I would say that the facts in Cochran and Martin, as illuminated in the Supreme Court opinions, simply don't meet this current standard for various reasons. I'm going to transition now from what the variance standard is to some of the other changes. I've been talking now for about 30 minutes, give or take, on the variance standard. I'm going to talk hopefully for maybe 10 minutes on the other procedural changes, and including the things that affect staff. And then hopefully we'll get some questions and we can talk some more about this. Procedural changes in the BZA process come sort of throughout the statutory amendments. There is a new equal time requirement. Honestly, I don't know what local government really didn't give equal time, but apparently there's at least one out there that allowed, I guess the staff or the county attorney or city or town attorney to go on at length about their position, and then limited the applicant to a certain period of time that was substantially less. And as is usual, I think that when those types of bad facts make their way to the General Assembly adopts a general statutory amendment that addresses it. In this case, it just simply says that both sides get equal time in these types of appeals, and that's fair. I think most local governments, in my experience, have in fact given equal time, and certainly that's good for the process of justice. Applicant does bear the burden of proof, as they always have. What is new is the preponderance of the evidence. There was a higher evidentiary standard before in 2309. Now it's bearing the burden of proof by preponderance of the evidence. It's simply a 51% of the evidence rule. And so if the applicant has 51% of the evidence supporting their position, then they win. And so that's really new. How that plays into what is unreasonably restrict the utilization of the property. It's kind of interesting because, as I said earlier, I don't think that the unreasonably restrict the utilization of the property is a new standard. It's certainly not. It was very difficult to prove before. I don't think the standard of what is in fact unreasonable changes, just the level of evidence that you have to bring on to prove it. And so I think this, it may be argued that this lessens the standard of what needs to be proven. That's not true. There's two different things: what needs to be proven, and then how much evidence you need to bring forward to prove it. The amount of evidence you need to bring forward to prove it has been reduced, but the standard of unreasonable utilization is really unchanged. Another sort of fairness rule is in 2308.1b. Materials have to be provided to the applicant that is appealing to circuit court within 3 days of the time they're provided to the BZA at no cost. On appeal to the circuit court, the same rule applies, and additional materials beyond what's provided to the BZA can be provided under FOIA. Let me talk the rest of the time before we start taking questions really on effects on the staffing on the BZA. because I know I've gotten calls from local governments about these limitations. I know a lot of zoning administrators and staff to BZAs are concerned about this because as before, they were kind of governed by local practice. Now they're governed by a statute, and there are these limitations. First of all, let's talk about who is non-legal staff to the governing body. First of all, and I think I've got a little later in the presentation, that is not the county, city, or town attorney. It says non-legal, and so it is just folks that you would typically describe as staff. Zoning staff, typically the zoning administrator, an assistant zoning administrator, or a staff person in the planning or zoning offices is typically assigned to staff the BZA and provide help to the BZA in doing things that they need to do, such as advertising their public hearings properly, making sure their meetings are scheduled, making sure minutes are taken. Quite often, BZAs will appoint a member of the local government staff to be their secretary to take minutes or things like that. So the question is, who is non-legal staff of the governing body? That really, as broadly defined, means pretty much everybody that actually advises or assists the governing body in their zoning matters. So really the only way you get to be non-legal staff of the governing body and you are in a zoning office is if you are, in other words, in order to escape this sort of broad definition, you have to be legal, like I said, a county, city, town attorney, or you have to be staff specifically, and I would say exclusively, to the BZA. I think that I've considered, and I think some folks have considered the idea that you might be staff to the BZA for certain types of applications and then staff to the governing body on other types of applications. If you are one of those local governments that is trying to sort of parse those words and do that, my hat's off to you. My feeling is, and whether it's legally required or not, that kind of parsing is simply confusing. I think it'd be confusing to the BZA. I think it'd be confusing to applicants and the public. I think it is better off just simply saying that you are either staff to the BZA or you're staff to the governing body, and you're really not both. And I think that it's probably safer for staff, who after all are lay people and are trying to apply this fairly technical statute. There are a couple of exceptions. For example, you can have ex parte communications if in fact it is not about the facts or law relative to a particular case, because the bar is actually discussing facts or law relative to a particular case. It's not about discussing scheduling, advertising, notices, things like that, applications of the bylaws in a particular sort of meeting rules scenario. Getting information out or communicating things in between BZA members or from staff to the BZA, as long as it doesn't involve the facts or law relative to a particular case. Other exceptions involve public meetings. Obviously, if there's a public meeting, that's not ex parte communication. I think that's self-evident, but I think it's helpful to put that in there. And also, it doesn't apply to meetings that the applicant is invited to attend. If the applicant is invited to attend the meeting, the non-legal staff of the governing body can, in fact, have ex parte communications with the BZA or BZA members, even if the applicant is not there, as long as they've been invited to attend. So what happens if, despite the best intentions of the non-legal staff of the governing body, there is some ex parte communications that violates this ban? It really has a fairly light thing that is required, and that is notice to the other side. It doesn't mean that the BZA doesn't have power to act. It doesn't mean that the staff is barred from the proceeding or anything else. It just simply has a notice requirement. If in fact there is an ex parte communication as defined by non-legal staff of the governing body as defined that doesn't meet an exception, then you have to notify the other side. And what kind of notice is required? All it says is substance of the communications. So you don't have to give a verbatim transcript. You don't have to say every word that was said to one side or the other. What is substance of the communications? Presumably the subject matter the types of things that were discussed, that kind of thing, it would be substance of the communications, presumably. But we may very well see this played out. Although, honestly, given the fact that there's really no limitation on the staff or the BZA, if notice is not provided, it may be the kind of thing that is complained about, but not often applied in an actual case. But who knows? I could be proven wrong about that, because folks do litigate over things that you don't expect. Like I said, it doesn't apply on its face to local government attorneys. It also does not apply to special exception legislative cases. In that kind of a case, those are not considered ex parte communications that are banned. For that, it really goes back to pretty much the standard in a rezoning case. For example, in a rezoning case or a special exception case, it's legislative. Can staff make recommendations and communication? Can they communicate with the decision makers? Yes, they can. But I think that's fair, because actually the applicants also can communicate directly with the members of the BZA, just like they can communicate directly with the members of the governing body in legislative applications. And that just goes back to the First Amendment. Everybody gets to petition their governing body when there's a legislative call to be made. One of the changes, one of the real results of all of these changes, the procedural changes, the staffing limitations, is to put all of the cases on a litigation posture. That's great for lawyers. Litigation posture, great, bring it on. We know how to apply these rules. We know how to sort of put things in a litigation posture. And so it's great for lawyers. It's probably fair. Certainly anytime you have a significant number of rules that talk about how things go, that's fair. I would argue that perhaps it's not really great for the BZA. At a time when the BZA is deciding things that are more complex than ever, such as vested rights, asking a BZA to go without guidance of staff that's been there, done that, is very difficult. Seems like to me that if I could suggest another amendment to this, I would simply ease up on the restriction on the non-legal staff and just simply, state specifically that applicants can have similar discussions and just sort of throw it open. And that way the BZA can be well informed by all sides. But that's not what the current law says. There are effects on appeals to the circuit court. The BZA still is presumed correct, as always. Their fact findings are given weight. The standard review is typically preponderance of the evidence. Like I said, the standard review is lower than it has been. The plainly wrong rule, if you go back and look at the old cases that were decided some years ago under the BZA statutes, the plainly wrong standard is repeated often. It's important to understand that that now does not apply in any case except those of special exceptions. It does apply in cases of a legislative determination by the BZA. Like I said, this is now more like a litigation posture. The rules of evidence now apply. Evidence is plainly allowed. That's now the rule. Well, I've been talking for about almost 45 minutes now on this. I certainly commend the reading of the bill to you, which is cited in the materials. I also commend a rereading of the Martin and Cochran cases to you to see how those fact patterns would be addressed under the current law. And I think that that probably will help BZAs and staff as much as really anything that that could be done. I do know that this new amendment certainly was intended to change the way variances are handled, and I do believe it does change how variances are handled procedurally quite a bit. As to whether there's an enormous change substantively in what qualifies for a variance, I think that is sort of remains to be seen. I'm sort of in a watch and wait scenario on this, a little like when the General Assembly amended the statute the last time after the decision in the Cochran case. I think there was a difference of opinion as to how much it changed, and we really didn't know the answer to that until Martin was decided 9 years later. I'm thinking that we won't have that long to wait this time, because the changes are much more significant as far as the text has changed significantly. And before you think that I'm sort of anti all these changes, actually, I think that in many ways I am in favor of it, because the statute before, particularly 2309, under sort of what does a BZA have to do to have the power to grant a variance, was written sort of in a scattershot way. It was spread throughout a number of different paragraphs. I think that the bill does clean a lot of that up, and it sort of consolidates a lot of the requirements. And as I said, a lot of them are current requirements and things that have been applied in the case law for many years. It puts them all into sort of a checklist foundation, sort of a checklist form. So you have to find one or the other of the initial points, and then you also have to find every single one of the other 5. And if you sort of go through that checklist and you meet the definition of variance, then you get a variance. If not, you don't. And I think that that's probably a very helpful change. Whether it changed the substance or not, I don't know. But it certainly, I think, made it easier for attorneys, zoning administrators, and BZA members as well to apply the law. At this point in time, I guess I'm going to be quiet for a minute and see if there are any questions on anything that I've said. Certainly, I welcome questions. I do recognize, and I will say that I am one of the attorneys that takes this position. I know there are many others, and there are certainly other attorneys that take different views, but that's why they have different attorneys. And so I am very interested to see how this will be applied by the court in an actual case. I also would like to preface all my comments to say that this is sort of an academic statement on my part, not on behalf of any client that I may have now or in the future, and that I certainly disavow any of the statements that I've made to be applied in any kind of a case that might apply now or in the future. Because at that time, of course, I'd be applying it to certain facts and specific facts that a client would have. And so therefore, I don't think these comments really would be all that applicable in a particular case. I think there's a question about credits, and so I'll be quiet and let Jonah talk about the credits.
Yeah, thanks, Andrew. If you want to go ahead and take your screen share off, we can see your face.
Okay.
And maybe have a little bit of conversation here. CEU credits, absolutely, Deborah. We're going to be trying to work with APA Virginia, try to get AICP credit for those of you who already have your AICP credit certification, but also for VZA members. I know you have some CEU needs as well, and I'm going to be reaching out to VZA to make sure we have that as a possibility for you. Now, Andrew, I think you've really gone through an enormous amount of material here, and I think you've pointed to the procedural changes maybe being more substantial in this variance issue than the actual possibility of seeing different determinations come out of the variance process. Has there been any clue, any evidence to suggest whether we're seeing more or fewer variances with respect to now that things have been cleaned up, as you put it, in terms of more of a listed a set of things that people have to meet in order to get a variance? Is there any, maybe we haven't had enough time between the decision.
Well, I think it's a good question. I mean, I think at this point it's all really anecdotal, because no cases have made their way up to the Virginia Supreme Court, and probably won't for another year at the earliest. But I will say that, anecdotally, I've heard from some of my colleagues and zoning administrators that there is more significant action, if you will, on variances than there had been in the past, particularly in urban places where the restrictions on the land use are both arguably more restrictive and also more economically valuable. And so where those things happen, I think you are seeing more applications for variances. And I think that there is some general belief out there amongst some folks that it should be easier to get a variance. But I would caution the people that believe that they still should compare their facts very carefully to the standard in the statute as amended, and make sure that they can actually meet all of those 5, 6, 7 things that you have to prove in order to get a variance. Because if you can't, then a BZA is really still mandated, as shown in the Cochran and Martin cases, to turn down the variance.
I see. And is that other perspective at all attached to this notion of either fairly debatable or the new language in their preponderance of the evidence, or is that just sort of a general feeling, sort of a culture shift, hoping that the legislation has a different result for them?
Well, I think that any time that there is significant legislation like this, there's a belief out there that it must have done something significant. And so it just that's just the way it is. And certainly the people that were behind this bill, I certainly, I'm sure, believe that. But in the end, there is no such thing as legislative history in Virginia. And so when a case actually gets in front of a BZA or in front of a court, what somebody thought that a bill did, or what some discussion in some committee in the General Assembly, or what some position memo by some group that was pushing the bill or fighting the bill, really is inadmissible for the purpose to show what the bill actually did. What the Supreme Court and what a circuit court would do, and what the BZA should do, is actually apply the language of the statute itself to the facts presented. And sort of that general understanding that it must have done something significant really doesn't apply. And I will say that in some cases, including in the Martin case, there was discussion about how there was this general feeling that there must have been something done to ease the variance. But in the end, the Supreme Court said, no, you still have to look at the statute, and the statute controls.
Well, and it goes to I think your point about people are trying to put some cases out there to see what the effect really was, how the decisions really are coming out. So it's being tested, and I think you're pointing to some evidence there that suggests that maybe there wasn't. It depends on how the outcome of these cases fall down, but we'll see. It's interesting. It's an interesting perspective. Yeah, I think another point that you made here, and sort of my last observation, was this idea that if there is a legislative perspective that can be gone down, that people need to look at that first. So if there's a special exception that's available to folks, they really should do that first before trying to seek a variance. Is that written anywhere, or is that sort of acknowledged as the pathway for change for folks that are looking to get something done with their property?
Well, it's really in two different places. It's both as the fifth mandatory finding that the BZA has to find in order to have the power to grant a variance. They have to find that there is no special exception or administrative modification that is allowed under the current ordinance. That's in there, and also the requirement the problem to be addressed by the variance is not so general or recurring to be addressed by a general regulation. That's also a mandatory finding by the BZA in order to have the power to grant a variance. The special exception modification thing is really addressed by looking in the zoning ordinance for what is allowed as a special exception, what is allowed as a modification. Consulting with the zoning administrator is very important with that, because they get to interpret those provisions to say, yes, that will help you, no, that won't. And of course, that alone could lead to an appeal from the zoning administrator to the BZA, not as a variance, but as an appeal from a zoning administrator, which we're seeing more and more of those as well. The other one, the no general regulation is possible. That is also, you have to read the entire zoning ordinance. Can I get at this through an amendment of the current general zoning language? If you can, then you need to approach your governing body, approach your member of the governing body, elected official, approach your zoning administrator, approach the folks that are in charge of the local government, and say, look, I've got a problem here. I've got an unreasonable restriction, in my opinion, that could be fixed if we had an amendment to the general code. Let's go try that. And perhaps in cases that could be done. And I will tell you, a governing body has a lot more leeway if they agree with you on that than a BZA does, because a governing body is in fact applying that fairly debatable standard. They can adopt a reasonable zoning fix to help you as a landowner, whereas a BZA is limited by the very strict language in the statute. They can either grant it to you or not grant it to you. They cannot change the language of the zoning ordinance itself, which a governing body can.
Very interesting. Well, I'm hearing a bit more of a procedural bent to things, but not necessarily a substantial change to how variances are issued and whether or not they're issued. So we shall see as people test this new legislation going forward. And I think that we'll just continue to keep people aware of what's going on and how it's coming out. But Andrew, thank you. Really appreciate your time spent with us today. Of course, you're always welcome to come back and do more of these Webinar Wednesdays with us as time allows. I know you've got some big things on your plate, and I look forward to catching up with you about all that stuff. So unless we have some other questions, Andrew, thank you so much.
Thank you, Jonah. Appreciate it. Thanks, everybody, for joining us, and apologize again for the technical difficulties earlier. Thanks for hanging in there.
Absolutely. And thanks again, folks, for participating in Webinar Wednesday. If you do see the chat box over there, feel free to leave us some feedback on the evaluation link that you see there at the top of the chat box. If you have other ideas for what you'd like to see on Webinar Wednesdays, get a hold of me. I'd be happy to work with you to make sure we cover the topics of interest to you. And anytime I can be of use, please reach out to us at planvirginia.com. We're always looking to make sure we're covering our educational needs as you guys see fit. So check us out on YouTube. Of course, our previous Webinar Wednesdays are there and lots of other material. Heck, you might even run into Andrew McRoberts over there. He's got a couple other videos he's done for us. So take care, everybody. We'll see you again soon.